Court delays have historically been a serious problem in Canada, with criminal trials that drag on and on and on. The situation finally came to a head in 2016 in a court ruling known as the Jordan decision. Named after Barrett Richard Jordan, a BC man who was accused of drug trafficking in 2008, it took 5 years before his case made it to the Supreme Court. Now, the Charter of Rights and Freedom says Canadians have the right to be tried in a reasonable time. Jordan and his lawyer argued that the delays in his case had contravened that fundamental right. The court agreed, and in its unanimous decision, tossed out Jordan's case. But then, the court went one monumental step further. It set concrete limits on what constitutes a reasonable time frame: 18 months for cases in the provincial court and 30 months for cases in the Superior Court. The move caused a stir, mostly because everyone thought those timelines were unrealistic. Everyone except the judges. In their decision, they criticized what they saw as a culture of complacency towards delay that had been accepted as the norm. Since the Jordan decision, a concerning trend has emerged. In the first year and a half, more than 400 cases were tossed out of court because they exceeded the Jordan deadlines. A man charged with murdering his wife, tossed after 56 months. A man charged with bank fraud, 51 months, tossed. A couple convicted of sexual assault on a minor, 45 months, tossed. None of the accused got their day in court. None of the victims got answers. So has Jordan really worked then to speed up the system? We spoke with lawyers across the country who say they've seen many changes. First, judges are triaging cases, and cases that are getting close to deadline are given priority. When scheduling trial dates, the court considers the deadline first and works backward from there. When the date is set, all the pretrial proceedings are squeezed into the months before to keep everything on schedule. Most lawyers told us there's a lot more pressure on everyone, Crown, defense, and judges, to make themselves available. Courtrooms are double, even triple booked, so that when one trial wraps up, the next one can begin right away. If and when either side delays proceedings for any reason, it is put on the record to document who caused the delay in case the trial goes over deadline. Even with all the adjustments, lawyers say there are still unforeseen setbacks. Adjournments, delayed evidence, witnesses who don't show up, judges who get sick. And multiple lawyers told us they're frustrated because simpler cases that would have been resolved in a matter of months before Jordan are now taking much longer because the whole system is stressed. In March of 2017, the Canadian Bar Association made suggestions on how to reduce court delays. Later that year, in June, a Senate report came out with 50 recommendations to improve the system. A main priority to fill what the senators called the excessive vacancies of federally appointed judges. Justice Minister Jody Wilson-Raybould has appointed dozens of judges, but vacancies still abound. As of March 2018, the minister still had 56 empty spots to fill, and a quarter of the nearly 1,200 sitting judges are already semi-retired. The minister's office told CBC she's committed to improving the system. She introduced legislation in March of 2018, but the courts will have to wait to see what effect it has on the problems. The Jordan deadlines may seem hard to reach, but it bears reminding that the Supreme Court judges told Canadians they shouldn't be satisfied even with these deadlines. In their words, this is a long time to wait for justice.